By the end of this hearing, the power he carried for years would evaporate. The authority that once cleared rooms with a single look would fail to protect him, and a police chief who believed he ran the city would learn, quietly, precisely, and without spectacle, that the city was never his to command. At exactly 9:03 a.m. on Monday, July 8, 2024, the bailiff called Courtroom 5A to order inside the Jefferson County Superior Court. The room rose in unison, not out of fear, out of routine. The kind of routine built by years of understanding that this space did not respond to personalities or titles. It responded to law. I took my seat behind the bench slowly. No urgency, no performance. The file before me was thick, bound with colored tabs and time-stamped exhibits. I placed both hands on it before speaking. "This court is now in session," I said. "You may be seated." The sound of benches settling faded into silence. "This courtroom operates on a single principle," I continued. "Respect for the law, dignity for the process, and equality in its application. Rank does not alter that. Wealth does not soften it. Influence does not bend it." I lifted my eyes and fixed them on the defense table. "And authority," I added, "does not excuse it." The defendant sat upright, shoulders squared, posture disciplined. His name was Michael Rourke, age 57, former police chief of Easton City. 34 years in law enforcement, decorated, publicly praised, politically connected. His career had been built on command, on the assumption that when he spoke, others complied. For most of his adult life, that assumption had been correct. Today, it was irrelevant. Rourke wore a tailored navy suit in place of his uniform, but the posture of command remained. His hands rested neatly on the table, fingers interlocked. His expression was controlled, bordering on indifferent. When he scanned the courtroom, it was not with apprehension, but with familiarity. He had stood in courtrooms like this many times, always on the other side. He had signed warrants, approved arrests, endorsed charges. Today, he waited. I introduced the case before the court. Multiple counts: abuse of authority, obstruction of lawful process, retaliatory misconduct. Each charge supported by documented incidents, recorded communications, and sworn testimony. "Mr. Rourke," I said evenly, "you are presumed innocent. This court will examine facts, not reputation." He nodded once, slow, confident. "The first incident occurred on Thursday, March 14th, 2024, at approximately 10:18 p.m. The location was Riverside Boulevard, a 5-lane road cutting through Easton's mixed residential and commercial district. The speed limit was clearly posted at 40 miles per hour. Restaurants were closing. Pedestrians moved along the sidewalks. Traffic was light but present. According to traffic camera footage later retrieved and authenticated, a dark gray unmarked SUV traveled through the corridor at 76 miles per hour. The vehicle was registered to the Easton Police Department. Officer Lucas Bennett, age 26, 2 years on patrol, observed the SUV pass his position near the intersection of Riverside and Grant. At 10:19 p.m., he activated his emergency lights and initiated a traffic stop. His body-worn camera activated automatically. The footage shows Officer Bennett approaching the driver's side cautiously, flashlight angled downward, voice steady. "Good evening, sir," he said. "The reason for the stop is your speed. May I see your license and registration?" The driver looked up. Michael Rourke smiled. "You just made a mistake," Rourke said calmly. Officer Bennett paused. "Sir?" he asked. Rourke leaned back in the seat. "I'm the police chief," he said, "and I don't have time for this." The camera captured the shift immediately. Officer Bennett straightened. His voice dropped slightly, but he remained professional. "I didn't realize," Bennett said. "I was just—" "You were doing too much," Rourke interrupted. "Turn your lights off." The footage shows Rourke folding his arms, relaxed. "This is my city," he added. "I run it. At 10:22 p.m., Officer Bennett stepped back from the vehicle. No citation was written, no warning issued, no report filed. The stop ended, but the body camera continued recording. It captured Rourke laughing quietly as he pulled back onto the road. For most drivers, that would have been the end of it. For a police chief, it became precedent. 2 days later, on March 16, 2024, at 8:41 a.m., Officer Bennett was called into his supervisor's office. He was advised unofficially that stopping command staff creates unnecessary friction. There was no written reprimand, just a message delivered carefully. The second incident occurred on April 2, 2024, at 11:06 p.m., different location. Maple Heights Drive, a residential street lined with parked cars and narrow sidewalks. The speed limit was 30 miles per hour. Again, the same SUV. Again, excessive speed. This time, Officer Rachel Kim, age 33, 7 years on the force, initiated the stop. Her body camera recorded the moment she approached and recognized the driver. Her shoulders stiffened. "Chief," she said quietly. Rourke nodded. "Let's not waste each other's time," he replied. No citation, no report. By the third undocumented stop, the behavior had stopped being accidental. It had become expectation. On April 9, 2024, at 7:52 p.m., Rourke entered a restricted department storage facility without logging access. When questioned later by a junior supervisor, he dismissed it as executive business. "I don't answer to paperwork," he said. "I answer to results." That statement would later appear in sworn testimony. But the moment this case truly escalated did not happen on a street. It happened online. On April 18, 2024, at 6:27 p.m., Rourke appeared in a short video posted to a private social media account belonging to a local developer. The video was recorded during a dinner gathering attended by several city officials. In the clip, Rourke raised a glass and said, smiling, "People think laws run cities. They don't. People do." Laughter followed. The video circulated quietly at first. Then it didn't. By April 21st, it had reached internal affairs. By April 23rd, a formal inquiry was opened. When Rourke was informed, he dismissed it publicly. "Politics," he told a local radio host. "I've run this department longer than some of these critics have been alive." That confidence followed him into this courtroom. As he sat before me now, posture firm, expression composed, I addressed him directly. "Mr. Rourke," I said, "you spent decades enforcing rules for others." He nodded slightly. "This court will now determine whether you believed those rules applied to you." The prosecutor rose from their seat. The first witness was ready, and the evidence waiting to be introduced would make one thing clear beyond dispute. This was not a misunderstanding, it was entitlement, and entitlement, once documented, leaves very little room for mercy. I glanced at the clock. 9:46 a.m. We had only just begun. At 9:48 a.m., the prosecutor rose from her seat and called the first witness. The movement was small, almost routine, but it marked the point where the case stopped being theoretical. The room leaned forward, not physically, but mentally. This was where authority would be tested against record. Officer Lucas Bennett approached the stand with controlled steps. He was 26 years old, 2 years into patrol duty, no prior disciplinary actions, no commendations that set him apart, an ordinary officer in every measurable way. He was sworn in at 9:50 a.m., his right hand steady, his eyes fixed forward. I watched him closely. Young officers often carry visible tension when testifying against senior command. Bennett did not. What he carried instead was restraint, the kind that forms when someone has replayed a moment so many times that fear is replaced by clarity. He began with the night of March 14, 2024. He described Riverside Boulevard as it appeared at 10:18 p.m. Streetlights spaced unevenly, restaurant signs dimming, light traffic moving steadily. He explained how the SUV caught his attention, not because it was unusual, but because it was fast, too fast. "I clocked the vehicle at 76 miles per hour, Bennett said. The posted limit was 40. He described activating his emergency lights at 10:19 p.m., pulling behind the vehicle, and approaching without knowing who was inside. He followed procedure exactly as trained. When the driver looked up, Bennett said, and smiled, I knew immediately. He repeated the words as they were spoken, slowly, clearly. You just made a mistake. I'm the police chief. This is my city. I run it. At 9:57 a.m., the body-worn camera footage was played. The courtroom heard the exchange exactly as Bennett described it. No shouting, no threat, just certainty, the kind that assumes compliance without needing to demand it. The room stayed quiet. Bennett testified that at 8:41 a.m., 2 days later, he was called into his supervisor's office. The conversation was brief. There was no paperwork, no formal warning, just advice. Stopping command staff creates unnecessary friction. That phrase appeared nowhere in policy manuals. It did not need to. It was understood. No citation was logged, no stop report filed. The incident ceased to exist in the system. At 10:09 a.m., Officer Rachel Kim was sworn in. She was 33 years old, 7 years on the force, widely regarded as reliable and methodical. Her testimony did not contradict Bennett's, it reinforced it. She described the stop on April 2, 2024 at 11:06 p.m. on Maple Heights Drive, a narrow residential street, parked cars on both sides, the speed limit posted clearly at 30 miles per hour. I clocked the SUV at 62, she said. She explained recognizing the vehicle before reaching the window. I knew who it was before he spoke, she said, and I knew what would happen if I wrote it. Her body camera footage played at 10:16 a.m. The exchange was brief. Let's not waste each other's time. No argument, no justification, just expectation. At 10:22 a.m., the prosecution introduced internal records, GPS logs, speed data, vehicle access records, restricted facility entry logs, each entry time-stamped, each aligned with officer testimony. March 14th, excessive speed, no report. April 2nd, excessive speed, no report. April 9th, unauthorized facility entry. April 18th, recorded public statement. The defense objected twice. Both objections were overruled. By 10:31 a.m., the courtroom screens displayed a timeline that required no interpretation. Pattern had replaced coincidence. At 10:34 a.m., the dinner video from April 18, 2024 was played. People think laws run cities. They don't. People do. The laughter in the video felt distant now, almost embarrassing in its confidence. I looked directly at the defendant. Do you dispute the authenticity of this recording? I asked. No, Rourke replied. Do you deny making the statement? No. Do you deny believing it? I was speaking generally, he said, not literally. I nodded once. At 10:39 a.m., I said, this court distinguishes general statements from guiding beliefs by repetition and behavior. The prosecution then introduced internal messages dated April 21, 2024, after Internal Affairs opened its inquiry. At 3:12 p.m., Rourke sent a message to a deputy chief. IA is fishing. Handle it. At 4:08 p.m., another message followed. Anyone who talked needs to remember where promotions come from. The messages were admitted without objection. At 10:47 a.m., I addressed the defendant again. You were aware an internal investigation had begun when these messages were sent? Yes. And you chose to send them anyway? Yes. I closed the file slowly. That is not leadership, I said. That is leverage. Rourke's posture stiffened. At 10:53 a.m., defense counsel requested leniency. He spoke of service years, crime reduction statistics, community recognition, letters of support. I listened fully. When he finished, I spoke calmly. Service explains history, I said. It does not erase conduct. I leaned forward slightly. When enforcement stops moving upward, I continued, it stops being enforcement. It becomes permission. I referenced the officers who testified, their silence, their hesitation. That erosion, I said, does not stay inside departments. It reaches neighborhoods. I paused. I have grandchildren, I added. They crossed streets, believing speed limits apply to everyone. The courtroom remained still. At 11:04 a.m., I informed both parties that the court had heard sufficient evidence. Final consideration would follow. Rourke adjusted in his chair. The confidence was still present, but compressed now. Defensive. Calculating. Because the record no longer served him. It stood against him. At 11:07 a.m., I asked the courtroom to remain seated. No one moved. The silence was no longer anticipatory. It was settled, the kind that follows when facts have exhausted every alternative explanation. I looked down at the record one final time, not to confirm what I already knew, but to acknowledge its weight. Dates repeated, times aligned, decisions stacked one upon another without interruption. I lifted my eyes to the defendant. "Mr. Rourke," I said calmly, "you spent more than 3 decades enforcing the law." He met my gaze. "You supervised officers. You disciplined misconduct. You reminded citizens that rules exist for safety, not convenience." I paused. "This court must now determine whether you believe those rules applied to you." I spoke deliberately. "You were not confused," I continued. "You were not responding to emergencies. You were not acting under pressure." I returned to March 14, 2024, at 10:19 p.m. "The words you spoke that night were not accidental," I said. "They were practiced. This is my city. I run it." "That statement," I said, "was not frustration. It was identity." I moved to April 2, 2024, Maple Heights Drive. "You enforce speed limits for others," I said, "but when the law turned toward you, you treated it as optional." I addressed the undocumented stops. "When enforcement stops moving upward," I said, "silence replaces accountability." I spoke of Officer Bennett, forced into quiet compliance early in his career. I spoke of Officer Kim, experienced enough to recognize the cost of honesty. "That is how corruption spreads," I said, quietly, professionally. I referenced the messages sent after Internal Affairs intervened. Anyone who talked needs to remember where promotions come from. That, I said, was intimidation. The courtroom remained motionless. I shifted to what mattered most. "I have grandchildren," I said. "They trust that a badge represents restraint. When that trust breaks," I continued, "the damage does not remain internal." At 11:23 a.m., I straightened. "This court will now rule." I delivered the verdict clearly. On all counts of abuse of authority, obstruction of lawful process, retaliatory misconduct, and official corruption, this court finds the defendant guilty. Rourke exhaled slowly. "Sentencing," I said, "is not emotional. It is corrective." I spoke each consequence slowly. This court sentences the defendant to 72 months in state custody, to be served consecutively, with no eligibility for early release. This court imposes a fine of $150,000. This court permanently revokes the defendant's law enforcement certification and bars him from holding any public office or supervisory role related to public safety. I paused. This court orders forfeiture of all departmental privileges obtained through misuse of authority. I explained each punishment. Prison, I said, because authority was weaponized. Fines, I said, because power insulated behavior. Permanent revocation, I said, because trust broken at this level cannot be restored. I looked at Rourke. "This sentence is not about humiliation," I said. "It is about restoring a boundary." I addressed the courtroom. "To officers," I said, "the badge is not a shield. To leaders," I said, "power without restraint is corruption. And to the public," I said, "the law does not bend upward." At 11:41 a.m., I nodded to the bailiff. "Mr. Rourke, you are remanded into custody." He stood slowly. The posture of command was gone. I waited until the doors closed. This court is adjourned. The gavel struck once, not loudly, but finally.